Hi, today we're going to talk about what is included in the estate of a deceased person. The reason this is important is because if an asset falls within the estate of a deceased person, then it's available to the beneficiaries. If an asset does not fall within the estate and falls outside of the estate, then it's not available to the beneficiaries. And the beneficiaries I'm talking about can either be the beneficiaries under a will, or if the deceased person died without a will, then the beneficiaries are the close family members as determined by the rules of intestacy. So let's start off by talking about the house. If the deceased person owned the house in their sole name, then it forms part of the estate. If the deceased person owned the house jointly with another person, then there are two ways that this joint ownership can be structured. The first is by joint tenants, and the second is ownership by tenants in common. So if the deceased person owned property as joint tenants with another person, then it does not form part of the estate. The reason is the other joint owners will automatically take ownership of the deceased person's share in the house, no matter what's in the will. It's known by a legal doctrine called the right of survivorship. And the right of survivorship trumps any will. If the deceased person owned a house jointly with another person as tenants in common, then that share of the house can be distributed to the beneficiaries and it forms part of the deceased person's estate. Bank accounts. Bank accounts are pretty straightforward. If the deceased person owned the bank account in their sole name, then it forms part of the estate. If a bank account was owned jointly with another person or people, then the bank account will not form part of the estate, and any money in the bank account will transfer automatically to the other joint owners. Superannuation. When it comes to superannuation generally falls outside of the estate because the superannuation money is governed by the terms of the superannuation trust. Basically, the superannuation fund controls the money. Now, there's only one way that superannuation money can form part of the estate. If the superannuation fund decides to pay the money to the estate, then the superannuation money forms part of the estate. If, on the other hand, the superannuation fund decides to pay the money directly to the beneficiaries, then the superannuation money will not form part of the estate. You can find out if the deceased person's super is paid to the estate by contacting the super fund and chatting with them, and they should be able to tell you where the money will go. Shares. Shares generally operate in the same way as bank accounts. If the shares are owned in the deceased person's sole name, then the shares will form part of the estate. If the shares are held jointly with another person, then the shares will not form part of the estate, and they generally will transfer automatically to the other joint owners. Generally speaking, if your loved one owned assets in their sole name, such as collection of artwork, such as personal property, such as motor vehicles, or anything else, then that will form part of the deceased person's estate. Let's talk about trusts. Any assets held in a family trust or a unit trust or some other type of trust generally will not form part of the estate. What you need to do is have a look at the terms of the trust deed to see how the assets will be dealt with. If your loved one owned a family trust, which is something at law called a discretionary trust, then it's unlikely to form part of the estate, and there's a good chance it is not part of the estate. If your loved one had a unit trust, then what's important is to consider who owns the units in the unit trust. If your loved one owned the units in the unit trust in their sole name, then the units will form part of the estate. Now let's talk about businesses. If your loved one owned a private company, then what we look at is how the shares were owned. If the shares were owned in your loved one's sole name, then the shares in the company will form part of the estate. If the shares were held jointly with another person, then it's important to have a look at the constitution or the formation document of the private company just to double check how the death impacts the share ownership and whether it forms part of the estate or not. It's likely that if the shares were held in joint names, then it probably won't form part of the estate, but it's good to double check. Life insurance. When it comes to life insurance, there are two types or categories of life insurance. The first is life insurance that is attached to a super fund. The second is a standalone life insurance policy. If the life insurance is attached to the super fund, then the life insurance will be treated in the same way as the superannuation money. If the life insurance is not attached to the super fund, then what's important is to have a look at who are the beneficiaries of the life insurance policy. The beneficiaries can be the estate. If that's the case, then life insurance money will form part of the estate. If, on the other hand, the life insurance policy specifies an individual as the beneficiary, then the life insurance money will not form part of the estate. I hope that has helped you understand what forms part of the estate and what doesn't. The reason this is important is because it will have a direct impact on how much inheritance the beneficiaries will get. I hope you've enjoyed this video. Subscribe to our channel for more information about what to do if you've recently lost a loved one.